right. I want to call this task force meeting on local government annexation to order. Madam Secretary, if you could please call the roll.
Senator Nemus, Senator Stivers, Senator Wheeler, Senator Yates,
Present.
Representative Bridges, Representative Chester Burton,
Here.
Representative Meredith,
Yes, ma'am.
Representative Pollock,
Here.
Senator Mills,
Here.
Representative Dixon.
Here. All right, and then some business we need to get out of the way at the beginning. I need a motion on approval of the minutes from the August 25th meeting.
Motion.
Got a motion? Can I get a second? Got a second? All those in favor say aye. All right, minutes are approved. And then if there are any members that have any guests in the audience they would like to recognize, you may do so at this time. Representative Bridges?
I'd just like to recognize the Mayor of Paducah, George Bray, and tell you I appreciate you being here today. Thank you.
Senator Mills?
All right. Thank you, Co-Chair Dixon. This really isn't a visitor as much as it is just a good time to make an announcement. Wes Southworth is out in the crowd. He probably doesn't even want me to do this, but he's been our staffer in state and local government. Most of you know him and have worked with him. He's been our staffer for the last 4 years, and we've been through some pretty good things in state and local government as Wes has helped guide us through all of our tricky subjects that we handle in this committee. But he's going to be moving on. This is his last meeting. And just want to say thank you, Wes, for all your help, and good luck to the next thing you step into. So take care. Thank you.
And then Senator Nemus.
I'd like to introduce our county judge-exec, Jerry Summers. I used to have property next to him, and he couldn't wait till I left. But now we're good friends, and he has done tremendous things in Bullitt County, and I appreciate it, and so do the residents.
All right. No. Senator Yates?
I'd also like to recognize our professional firefighters are here with us today. Thank you.
Thank you. All right. Seeing no more, we will move on to our first. Excuse me. To our first item on the agenda, the Kentucky Association of Counties, Jim Henderson and Shelley Hampton. If you could please approach the mic, introduce yourself, and you may proceed.
I was like, you don't want to sit by me?
Yeah, well, I'm trying. I'll sit. Thank you, Chairman Dixon and Mills. Jim Henderson with the Kentucky Association of Counties.
Shelley Hampton with the Kentucky Association of Counties.
So, you see a big crowd gather. I tell you, I've been pleasantly surprised with the number of folks who have made their way to Frankfort on a Friday afternoon for these meetings over the past few months. I think that shows the level of interest in this topic. I want to thank you all, in particular, the members of this task force, for being willing to serve. Hopefully you were willing to serve. I don't know how that process works behind the scenes, but thank you for making the time to tackle what is undoubtedly a tough issue, issue that may have made you all feel like you've kind of been put in a spot you didn't want to be in. But even so, over the last couple of task force meetings, you've heard from different groups of folks talk about this issue. The first meeting was primarily educational at the invitation of the two co-chairs. Some folks, it was kind of a Henderson love fest at that first meeting. The Henderson city attorney and county attorney talked about the process and how it works and all of that. Last meeting, you heard directly from county officials and city officials on their perspectives on this issue. So we don't want to replow the ground that's already been plowed over the last couple of meetings. And the truth is, I think most of the members of this task force understand this issue. Not a lot of reason to talk about the whys and the wherefores and the how we got here. We will need to make a few important points today, I think, that are may seem repetitive, but they're relevant to the type of conversation that we'll have about maybe solutions or ideas for a path forward today. And that's really the primary focus for us today. Again, when you've had this much time to have the issue out there, I think you all expect from us, and certainly we want to begin making a pivot in the conversation from, what's the problem, what's happened, why are we here, to more of how do we move forward? How do we offer some ideas to move forward? We've got a booklet, I think, that's in your packet that really is just a resource document for you all. We're not going to reference this per se in the testimony today. It's just a fairly written in layman's terms, a document on our perspective on this issue. And again, we'll point out some things in that. I want to also just mention as we testify today, again, we're here officially today to present on behalf of KCO, and I think our city counterparts would appreciate the fact that we have a job to do today. We have to address some things that may not be pleasant, may not have everybody feeling good about what we say when we're done, but I think it's important for us to put some of those things out there on the record officially from the KCO perspective. There are parallel paths that I think that we are on today that we continue to have good dialogue about how we can move forward, whether inside this room or outside of this room. And so, again, today is about what we do inside this room. As we focus on how we move ahead, you might ask, well, what does that look like? And today, Shelley and I are going to hit on maybe 3 focus areas that we think really are part of a plan forward or a path forward on the issue. One of those, and again, Shelley's going to talk about this in a minute, is something we've called level the playing field. We talked about it. We testified in front of both the House and Senate local government committees almost a year ago now and presented our thoughts on the idea of leveling the playing field. That's an important part of the path forward for us. We also believe that there should be a stronger emphasis and stronger overall interlocal agreements. We think that's a really important part of the path forward, and we're going to talk about that today. And we also believe that it would be very helpful if annexation itself, the process, was more thoughtful and perhaps a little more deliberate and planned. And we'll talk about that again in our testimony. But those are kind of the 3 areas that we think are part of a solution moving forward. I'd like to get a couple other things out on the record that I think maybe ought to be said so that there's no question about that. 2 things can be 2 things can be true at the same time. 2 different things can be true at the same time. Counties can be and are in favor of our cities flourishing and growing and being successful. We see the value in the role our cities play. And we can also not like the current situation that involves the situation that we mostly talk about, which is the revenue loss that happens through annexation. And so, again, I think today we'll be dancing around both of those areas, and they can both be true. Again, we're not against city growth. We're just opposed to the process that ends up taking revenue from the county budget when that happens. I also want to say one other thing. No proposal that KCO would put forward would involve taking 1 penny away from a city budget. I think that's important because, again, part of why we're here is the process today automatically results in a loss of revenue to the county budget in certain situations. We don't offer a solution that would adversely affect the city budget in any way. And so I think it's important to say those things and have them on the record. So I'm going to kick it over to Shelley. She's going to go back or go through some of those points I mentioned, and then she'll kind of pitch it back to me for a final point and the wrap up. So,
Good afternoon. Can you all hear me okay? Thank you all for having us today and tackling what certainly for us is a very monumental issue and for our members, and one that could have generational consequences for the better for all Kentuckians. As Jim said, I'm going to focus on one of the most challenging parts of annexation for counties. It involves that natural tension and conflict that annexation creates when county revenues are forfeited. The most negative financial impact to counties comes when cities take the occupational tax revenue upon annexation. But by virtue of statutes written by nobody here, a current annexation law results in a negative impact on some cities or some counties. This happens as a result from a 1986 law. This law applies what we all call and know as crediting. When a city expands its boundaries through annexation, the occupational taxes that were collected by the county are now surrendered to the city. This not only leaves the county with an immediate revenue loss, it also results in the lost opportunity of any future growth. This creates a natural conflict, even if all the parties otherwise have a good working relationship, which for the most part, I believe that is the case today in Kentucky. It's a law that's nearly 40 years old, and that tension has been growing for those last 4 decades. If you'll recall, last month at that meeting, even a city of 700 can unilaterally take away the revenue from a county of 140,000, and that just doesn't make sense to us. The law also applies an arbitrary population threshold of 30,000 and above that in 1986 may have only applied at that time to a handful of counties. In 2023, there are 34 counties, not including Jefferson or Fayette, with a population greater than 30,000, and the number is only set to grow. Of those 34 counties, there are 9 that have been grandfathered in over time. Oh, I should. You're right. Thank you. There are 9 that have been grandfathered in over time. More recently, there was a fix after the 2000 census when 6 counties surpassed that 30,000 population threshold. Yep. Let's see. Sorry. Because of the population growth, they were in danger of losing their authority to continue collecting that tax countywide. Without that fix in the law, Scott County alone, which was one of the 6, would have lost approximately $7 million in annual revenue. It would have been devastating and would not look or function like the Scott County of today. This is what County Attorney Amy Milliken was talking about last month when she said that if the same laws that apply to annexation in Warren County were applied to Scott County, it would cost them today $12 million a year. Warren, Madison, Davis, and others were just at different population points and used different methods of enactment at the time when these laws were written. So the focus, as we see it, is this. It's not so much that the current law treats counties and cities differently, as it is that the law arbitrarily treats some counties different from other counties. Representative Meredith, you said at the last task force meeting that this wasn't an annexation problem, it was a revenue problem. Regardless of how we describe it, annexation wouldn't be nearly the problem it is for counties if it wasn't a revenue grab from a county budget. This ongoing issue, being exacerbated in some of our counties, is a primary reason for why we're having this discussion today. If left in place, these laws that pit the budgets of counties against cities will continue to lead to conflict. Instead, let's fix this problem. While we have this moment in time, let's fix this problem and craft a solution. The simplest way to significantly reduce the annexation anxiety in the state is to first address the problem with these 25 or so counties that are treated differently under the current law. To be clear, in 93 counties, right now, 93 counties, when a city annexes territory, the county does not lose any of its occupational tax revenue. And if anyone might suggest this practice hindered economic growth, you only have to look at some of the fastest growing counties in the state. Boone, Kenton, Scott, Campbell, Nelson. All of these economically booming counties are not threatened by annexation because their budgets don't take a direct hit, and it has not slowed down them at all. So why wouldn't we fix this problem for the remaining counties? We believe this would be the best path forward to significantly reduce the tension that exists regarding annexation, particularly in these counties. Oh, sorry about that. There was a lot of testimony last month about how well interlocal government agreements are working and pertaining to revenues in some of our counties. We believe that interlocal agreements are absolutely a part of the path forward for cities and counties, but there have to be assurances in place that both the county and the city have something to leverage to cause the agreement to work. Today, the way the laws are written, in those over 30,000 population counties affected by the occupational tax crediting issue, as well as in every county that has an insurance premium tax, that's every county that has an insurance premium tax, annexation is a zero-sum game for the county. The county has no leverage to cause an interlocal agreement to be negotiated. You heard testimony from at least 2 mayors from cities located in those counties over 30,000 where occupational tax is affected by annexation. In both of those counties, like in the others that have interlocal agreements, the very existence of an agreement is largely a result of the personalities in elected office at the time. We can no longer rely only on a hope of personalities. We're also hearing from some of our newly elected judges, executives, and fiscal court members where the current agreements in place are being threatened. you can actually read about some of these situations in the news. And some of these counties that we've heard from about their situation actually asked us not to mention them specifically for fear that it could further jeopardize the situation they're in and the talks that they're trying to have with their city or cities. We do think another part of the path forward that's worth more exploration is what Representative Bridges suggested last month. Perhaps the requirement of an interlocal agreement when annexation occurs, when loss of revenue for the county is at stake. And the interlocal agreements must have mutually required approvals for negotiating or changing the terms, like a handful of them already have now. The effect of that boils down to this. In practical effect, right now, current law gives the city the only real leverage when it comes to choosing to amend or withdraw from a revenue-based interlocal agreement. Interlocal agreements can be a valuable tool in the process. We believe with both counties and cities having equal involvement in the negotiation, the specific sharing of revenues collected would be tailored to each local community's circumstances. While all counties have many mandated constitutional and statutory duties to carry out on behalf of the state, some counties may provide certain services where revenue sharing with the city certainly makes sense. Those general revenue sharing and expense sharing decisions, we believe, are still best left local to decision makers, but only if both entities have a true availability to negotiate. For example, if both county and city have planning and zoning or, say, building inspectors, it could be best that there be a consolidated approach to that as the city expands. Sharing fees and expenses, those kinds of specifics are still best determined locally. And as a rule, we have consistently encouraged the use of interlocal agreements where it makes sense, capturing the intended efficiencies that can be gained through them, whether that's county to city or county to county. And we have long trained our county officials on the use and application and encouragement of those interlocal agreements. Another county revenue source that is in jeopardy when annexation occurs is the insurance premium tax. The insurance premium tax is different from the occupational tax in how it is levied. A county can be selective on what is included and levy it only on insurance policies that are paid for by those outside the corporate city limits if it so chooses. In some situations, some counties may have made conscious decisions to use those revenues for services they deem as primarily serving the unincorporated areas. However, they shouldn't expect to lose those revenues further through annexation. We propose that where both counties and cities are collecting an insurance premium tax and annexation is initiated, there be a sharing of those revenues rather than a complete surrender of all those revenues collected by the county. An interlocal agreement could be an incredibly useful tool for negotiating a sharing of these revenues. But again, it must be an agreement where both parties have a reason to want to negotiate. What we must be careful to do throughout this process, regardless of any new interlocal agreements reached, is to find a way to solidify any current agreements that are set to sunset or expire or could be arbitrarily canceled by a city. There are a few out there that need to be protected in order to protect the county government from financial ruin. A couple of the judges in the room here today are facing uncertain situations just because there have been changes at City Hall. Again, our members feel the path forward is to strengthen the use of interlocal agreements where annexation adversely affects county revenue streams. Counties believe this will dramatically improve the climate for annexation. And now I will turn it over to Jim to address our final point and wrap up our testimony.
So you've heard Shelley. There we go. So you've heard Shelley talk about two ideas in a path forward. I mentioned all three at the beginning. I'm going to cover the third focus area where we believe meaningful change should occur. And again, I said this at the beginning. This is what we were calling thoughtful annexation, or maybe another way to say it is to make annexation make sense. And I think the focus area for improvement could really be best illustrated if you just look at the maps that we've provided to you. And we've provided some of these maps in the past. There's a list of every county in that booklet we gave you that shows the annexation or the city boundaries for each county. And again, I think if you look at the city boundary maps of recent years, it really tells a story of how some city annexation looks to be out of control. And even if there were no revenue loss, in these areas of annexation. I think counties would be talking about some of these haphazard, shoestring, corridor, spider web, whatever the terms are that people use to describe these types of annexations. And you heard testimony last month from the judge in Johnson County who isn't adversely affected by revenue loss through annexation, but talked about the challenges that come when these types of annexations occur. I think we can all appreciate and understand organic city growth that happens near existing city boundaries. And as cities continue to grow and run out of land for city services and the types of things that people want in the city, all of that type of annexation makes sense. And even though in some of those cases it still does affect our revenue streams, I think principally the way in which cities grow organically like that are things that you can't necessarily suggest that a city shouldn't be growing. We just make the argument that it shouldn't be at our expense. But in some of these cases that you see across the state, it just looks like it's not really the spirit of the contiguous and adjacent that the laws talk about when it talks about annexation. I know there are communities where cities have annexed over the tops of mountains to get to particular job creators that paid occupational tax. I mean, literally over the mountains to get there. Just talking with the judge in Pulaski a minute ago, and he actually clarified, I thought it was 2 miles. He said that they had annexed 10 miles each direction down the shorelines of the Cumberland River in Pulaski County to extend the city boundaries. We hear stories about down long legs of county road or road right-of-ways or utility easements. Those types of annexations aren't really a natural outgrowth of the city boundary. They're kind of using the court cases that we have on the books that have said that current contiguous and adjacent descriptions are so ambiguous that it's really left up to interpretation. We just believe that's not the right way for annexation to occur. And it creates its own set of challenges, again, as you heard testified in the last meeting. At the very least, we believe a city should have to provide some type of plan for services as a condition of annexation. And many other states have required just this, that in order for cities to expand its boundaries, that they actually have a plan, that they lay out a plan for what they're going to provide in exchange for being annexed into the city. 5 of our 7 neighboring states require this in most situations. You had this information, I think, actually early in the task force that you had LRC staff gather. Tennessee, Ohio, and Indiana require cities to provide a plan for services in all annexations. These plans spell out what additional services might be provided when a property owner or what a property owner might expect and when they should expect them and how the city will finance the extension of these services. Here's some language that might be interesting to you. It talks about a statement that sets forth a plan for a city to extend to an area to be annexed. Talks about extending police and fire and garbage collection and extension of streets and major water trunk lines, a timetable for how that works and how the taxes are going to be levied and used to pay for that. That's actually in statute today, in Kentucky Revised Statute. It just applies in one city, a first-class city, the city of Louisville. We think that's a pretty decent model for how you would spell out what it is that a city intends to do when it annexes. We think it's just good public policy. We also believe, again, without regard for any revenue issues on the county budget, because counties hear these kind of concerns. The county officials are often the people who hear from people who are faced with some of these annexations that really aren't, again, in the spirit of maybe even the consent to annexation. It feels wrong to, and unfortunately I saw some of this in my previous role, but to see that folks are coerced or required to sign consents to annexation sometimes in order to just get water or sewer. Now again, I think that people could reasonably expect that if that's a new investment by the city and that's a brand new customer, that there's an expectation that they pay for that. But in some cases, you have water and sewer that's been operating as a utility when it was good business for the city to run out in those areas because they just needed customers. And that's long established. And people who've lived there for a long time haven't been in the city limits. They've just been customers. And as those things turn over, you see a requirement for people to sign a consent to annexation to get their water turned on. I mean, that hardly seems like kind of the spirit of a voluntary consent to annexation. And so, there are those examples out there that we think are part of this third leg, which is a better way to annex, a more thoughtful way to annex, and one that is certainly not one that's adverse to property owners when maybe sometimes there's not much choice but to sign up. There are cities that actually utilize the economic development statutes that we have that are designed to be used to entice business and industry to move into Kentucky, and you can abate property taxes and give incentives to do that. But there are practices where that's actually interpreted because the city boundary moves, that somehow the business is now located and entitled to incentives and things like free garbage and things like that. Those things seem like not the same as a consent to annexation or a genuine growth of the city. We think those things ought to be looked at and part of a discussion about this section, which again, annexation that makes sense. None of these things really seem like kind of that good old-fashioned interest in people just being in the city, which we do recognize exists, and people want certain services and voluntarily want to be into the city limits. In some of these situations, many of these cases we described have incentives or other things that actually hit the county budgets with a revenue grab as well. In some cases, it actually makes economic sense to sign up to get in the city because the net effect is less for a period of time because the county taxes are no longer able to be collected. So again, we believe that this is something that needs work. And a final thought on this topic, we also believe that there should be an approval process or some objection opportunity at least for property owners and not just residents. As most of you know, only a resident can object or file a petition to be opposed to that. And we believe that should apply to property owners as well. So if you own a business or a home or a farm and you're not necessarily the resident in that home, but you own it, that you should have some say of objection if you don't want annexation to happen. Schools, I know, have also been an issue that's been brought up, and they were included in the moratorium as an absolute hands-off. We think school boards, because in many cases in our smaller counties in particular, the schools are the largest employer. And so it's ripe for annexation because occupational tax revenues are there. I understand it, but it should be that the school board or someone would have the opportunity to say no if they did not want to be annexed, and especially if there aren't any defined services particularly beneficial to the school as a result of that annexation. School boards, hospital boards, large employers that maybe wouldn't fit under the industry standard that's already in law. Counties, maybe the county fiscal court. Not to say yea or nay to annexation in general, but if the county owns the property. I know one of the judges in the room told me about a situation where the city was annexing their jail in, and no real value to the county for that to happen, but there's employees there and there's wages being paid. It's just essentially another hit to the wages of the employees there, or the county barn or something like that. In those cases, you'd think the county itself, since they own the property, could just say no. But the current situation doesn't allow for that. So in wrapping up this point, we do believe there needs to be work on the process, again, requiring it to be more thoughtful and it to be more about a real adjacent, contiguous annexation. So that's our three focus areas. In closing, I want to assure the task force and the General Assembly that our intention is to work through these issues with our city counterparts and with you to come up with an agreement in time for the 2024 session. That's our commitment. But we believe these three things should be part of that discussion. We think these are reasonable parts of a path forward. Shelley talked about leveling the playing field. We think that all the counties should be treated very similar in the way in which they're able to continue to collect their revenues if annexation occurs. On the strengthening of the interlocal agreements, this is one of my favorite mugs. I'm a child of the Reagan Revolution, and President Reagan is kind of the person maybe inspired me to public service, and I look at this every day to remind myself it's one of his slogans. He borrowed it. It's a Russian proverb that he used when he was negotiating with the Russians, and no intention there to imply, that this is like the Cold War between cities and counties or anything like that. But, President Reagan talked about trust but verify. On the interlocal agreement conversation, I mean, it's nice to think that everybody's just going to agree, right? And there's even comments last month like, shouldn't we just all agree that we can, work together? Well, that'd be nice if that's how it works. But the truth is, in most negotiations and most contracts, and most things you all do here, you might trust, but you got to verify. You got to have something that makes sure that that's real. Another saying he had I liked was peace through strength. Again, I think we want to get to the place where we're not at odds with our cities on this, but we have to be coming at that from some level of equal strength. Nobody can negotiate from a place of weakness, not a very good outcome at least. And the final point I just made is we really think annexation should make sense. So I do want you to know that our two executive committees, the elected officials of both the county or CACO and KLC, have had some productive conversations. We've been talking outside this room. And again, as I described at the beginning, I think it's important for us to maintain these parallel paths. And we look forward to some type of resolution before the session convenes. Counties and cities have a lot of issues we need to be working together on. And the things that unite us are greater than the things that divide us. And we believe that. I think most county officials would agree. So the changes we've outlined here, I think, will allow us to do that for the good of our common constituents and the maximum effectiveness of both counties and cities. So thank you, Mr. Chairman, and we'll stop there and open it up for questions if there are any.
All right. Thank you both for the testimony. We will entertain any questions from members at this point. Senator Stivers.
Thank you, Mr. Chair. I'd like to maybe pose two questions. One, Shelley, you used the term arbitrary in setting the 30,000 population rule. I've had this discussion for years. Why has not somebody challenged something that is believed, and I think you said it 3 times, arbitrary? Mm-hmm. Because no law can be arbitrary. There has to be some rational basis, something there that has some type of nexus to the reason or rationale of the law. Mm-hmm. And what you're seeing are people who may be on a boundary line, being in a county of less than 30,000 and a county of greater than 30,000, being treated differently from the perspective of a taxing situation because of what you described, and I agree with you, as an arbitrary setting of a numerical figure. Has anybody ever thought about just challenging that issue in court? And why not?
Well, and we have had many conversations over the years with you and a few others about that very point. I know that throughout the years that we've had that conversation, for the elected officials, my members who have been in the room, it's do we really have to get to that? Do we really have to go to that extreme? Can we not use the interlocal agreement process?
With all due respect, it's been 30 years.
I understand.
Sometimes it has to kind of come
and
to
I think that's where we're at. I think if you all will recall, if you were in the room when we testified last November, and Jim first brought this really to a major priority for us, and certainly for our members. I think that started a conversation finally that we need to sit down and talk about the inequities that exist. So this is our next step in that process, but it may not be our last.
Could Mr. Chair, one other question, not necessarily directed at this group, but Jim, you said trust but verify. I'm looking through all the maps, and it may be best focused towards JD and the KLC. Would you all agree that these are accurate maps that they have produced for us? About 12 miles of corridor or string annexation. Look at the city of Somerset, the city of Greenup, the city of Christian. JD, do y'all think these are accurate? So, trusting but verifying.
Trust but verify. I have no reason to doubt that they have inaccurately represented. But I sure would like to see. It started to float out on the internet, so I have gotten a call from a few cities that say, "Wait a minute, that's not right. It's not connected." So, but we'd have no reason not to think that they were being fully honest in their presentation.
And I was going to say, I mean, obviously, I've not, nobody's disseminated this document before today, widespread. We saved this for you all first, and then we'll certainly disseminate it to the general public. But we pulled that information from the Secretary of State's website. I think all cities are supposed to file their boundaries with the Secretary of State, and we use kind of a whole host of ways to verify if that we thought that wasn't accurate from things that maybe we were able to see otherwise. But again, I assure you, there has been no attempt by any of our staff to particularly manipulate anything to make it look like anything it's not. These are just straight off. In fact, one of our communications team and her staff spent a lot of time on this, completely apart from our advocacy team, just literally creating the visual from those documents. So if anything there's inaccurate, it is completely because either the accurate information is not publicly available or it's not correct with the Secretary of State because it hasn't been updated or something. So,
If I could, just one more point, Mr. Chair.
Yes, you may. Senator Stiver.
This is not really a question, but it is something that has occurred. I don't think this annexation issue is just a county versus city type of issue, because there is currently litigation in my backyard that a city annexed 12 miles down an interstate to annex over top of another city's infrastructure that was valued some 50 years ago at $40 million. I don't know what present value today of a 50-year-old $40 million investment would be, but I can tell you it's worth more than $40 million today. So rules about annexation and where infrastructure are, and I look at Judge Taylor from Madison County, you've got two cities that are within a mile of each other, I think. Are they touching now? So this annexation rules are not exclusively a battlefield for city versus county. I think the cities versus cities need to start developing structure for what annexation will look like.
Next question, Representative Meredith.
Thank you, Mr. Chairman. I also have a couple or three, if that will be okay.
It'll be okay.
And this, I don't know whether Shelley or Jim, either one, want to answer this, but we've always talked about the grandfathering issue on those counties that are above 30,000. What I think probably me and even most of the other members of the panel were not aware of are the different formats for that grandfathering and how they occurred. Mm-hmm. Can you go a little bit deeper into all that? I know you've got the map there, obviously, but to go a little bit deeper into how all of that developed, because it appears there's about 4 different ways that you could have been grandfathered.
Yeah, for one of them, when we referenced the 1986 law, anybody that was already on the books did not have to credit. Anybody that already had that on the books did not have to, on a go-forward basis, credit. For others, they had it put on the ballot as a referendum question. And who am I missing? Is that?
Yeah, I think Boone and Jessamine were enacted prior to 1986. Kenton and Campbell were both enacted, and I think they were by referendum. No, yes,
That's what the map
that's
shows.
correct.
Yeah,
That's
correct.
They were.
And then counties which enacted prior to reaching 30,000,
Those 6.
Boyle, Clark, Marshall, Nelson, and Scott. Some of those were specifically fixed when the population changed in 2000, but some of those have been since.
But those were frozen. Just as a point, those were frozen in time. And we actually had one county that said, I would really like to sit down with my city and negotiate one rate, one collection point, and a distribution, a percentage distribution based on who does what services. But if they had changed their rate in any way, they'd have automatically gone back down to the 1%. And at that time, and this was 20 years ago, it would have cost them $700,000 a year.
Well, I think the one that I was probably the most interested in, you've got credit required agreement in place prior to reaching 30,000, credit required enacted prior to reaching 30,000. And can you speak to the difference in those two things just a little bit, I think?
Hold on.
It would be the...
Is it on the map?
Yeah, it would be the orange and the purple.
Hold on, we'll go back.
Would be the two
the
that
purple
are
were counties. Again, they enacted the occupational tax before their population went over 30,000.
And so by an act of the legislature, then they were frozen. Is that something that dates back to the 86, or did that get frozen?
That was
after?
the change made after the 2000 census.
Okay. And then the orange ones would have been ones that knew they were approaching, I guess, and went ahead and did some kind of an interlocal agreement with their...
Well, that's only, I think, Montgomery. I think that's the county. We don't have names on all those counties. They're so small to put the name on. But that is a unique situation there.
Okay.
Where they agreed before there was an issue to share.
So move from that topic onto another one. And this part is more of a comment probably than anything. And I just... As we continue down the path of this discussion about shapes of cities, this is something that I really want to bring into account. And I bring into account because I look back and I think for those of us who don't have a broad knowledge of the geography of the entire state, maybe, you have to put a lot of this into perspective. And I'll give you an example. I'm going into my district right now, looking at Edmonson County. You could appear to have a corridor annexation when you look at the city of Brownsville within Edmonson County, because there is a portion, if you look at that, where it's very narrow and it almost looks like you'd have what would be two different cities tied by a very small pathway. But if you know anything about the geography of Edmonson County, there's only one way to cross the county, and it's a bridge that crosses the Green River. And so though it appears that you might have two little cities there on each side of the river otherwise, what has happened over the years is the ground below the bridge and around that river is river bottom ground. You can't do anything to develop it. You can't do anything to put industry there, to put business there, because it floods constantly. And so if you didn't, but you also have on the other side of that river, on each side of that river, you have what is kind of the central business district, the historic central business district, and kind of the more modern central business district of the community there. And so when you see that little small corridor path there, and it's not very stark in our situation, but you can see it, it's really because of the land use of what that property is for there. And there's always going to be shoestring annexations that we can call into question and we can worry about. But I think by just looking at the shape of a city, you have to be very, very careful, because you're not also looking at the geographic nature of some of the things going on in those communities. And we have to be careful of that when we have that discussion. Followed with, the other part of that is when you see some of these expansions that have missed an area and gone into another area, what I want to be careful of thinking about is, what might have happened if we had not had an annexation in that area? Would a new city altogether have popped up and created as that community grew? And would we have not had, 400 cities? Would we have had 600 cities? Would we have had 800 cities statewide had the annexation not taken place and the groups of citizens in that area had come together and created a new city by virtue of that? And so I just think that argument about the shape of the city, certainly there have been a few questionable ones out there. There's no doubt about that. I think we can all agree to that. I do think we have to worry just a little bit about looking at the shape of the city without all the other circumstances out there that go along with that, and the potential for expansion of the actual amount of incorporated areas. We've talked about Jefferson County a little earlier. We got 81, I think, small cities, 82 small cities within Jefferson County now, on top of Louisville Metro. And is it really in the state's best interest to have that many small cities, or is it not? That's a debate that we could all have, certainly, and kind of had over the years. But would annexation of some of those cities been better than to have all those individual cities, or what was the best path? Again, that's me pontificating for a moment, I guess you could say. And then the one other question I have, and I know it may not be the full ability to challenge, but there is some provision for a challenge by a property owner that's not a resident to put that on the ballot or to challenge that in court. Is that correct?
I think there's something that has to do with there's a ratio like on industry, which are not non-resident properties. But as a rule, I don't think so. Again, I'm not. There may be some nuance that I'm not aware of, but.
Okay, I was thinking that a property owner could force it to a ballot initiative, even if they were not a registered voter in the area. And I was thinking that there may have possibly been standing to challenge an annexation in court by a property owner, even if they weren't an actual registered voter there. That may be a nuance too, but I was thinking
they can. I think they can't vote if there were like a petition to oppose an annexation. So if you had an action to go out and actually annex where the opportunity to oppose allowed for petitioning to put that on the ballot, they would not be able to vote in that.
Okay. Thank you, Mr. Chairman.
Representative Pollock.
Thank you, Mr. Chairman. Just to clarify one of the comments, I think it was Shelley, 93 counties, annexations, not an issue. Mm-hmm. Is that? Mm-hmm. Is there any way, I'd like to focus a little bit on that, and I guess how are they making things work, I guess is my question, with those 93 counties, and it may be due to population. I don't know. But obviously, if that's working for them, why not consider a model of different types? And again, I know we've got Jefferson County, we got Louisville. I know all of the process, but I'm just trying to clear the weeds through it all and try to see how or why it's working for these 93 counties.
Well, so I believe it's 85 or 6 that are below the 30,000 threshold. And so if you're below the 30,000 threshold on your population, you collect countywide.
This is on occupational.
I was getting there.
Yeah.
On occupational tax. Now, on insurance premium tax, everybody has to credit. There is no over 30, under 30 on insurance premium tax. So we're just talking about occupational tax. The balance of that are those that we talked about that are grandfathered in. They did it by referendum. They did it before 1986. They were frozen in time in 2001 or 2, whenever that got enacted.
So the 30,000 kind of threshold number there is kind of the wavering part, because when you say out of those 93, 85 or 86 of those counties
are under that population.
Or underneath that population.
Right, and last month when Todd Mansfield was here testifying about Todd County, they would not have gotten the most significant economic development project in their history without both the city's occupational tax and the county's occupational tax to levy in those discussions. So that funding was critical for that.
It's curious to me to go back to President Stiver's comment on the 30,000, being a challenge, so to speak, I guess, overall. So that's all I got, Mr. Chair.
Representative Bridges.
Thank you, Mr. Chairman. Just looking at the maps that's currently on the screen, looking at Owensboro, Prestonburg, I think Somerset, I'm seeing a lot of holes in the cities, and I'm assuming that's county property, or that's county, that's designated county in the city.
Unincorporated areas.
Unincorporated areas. And it's been a few months, but I did get some calls from some situations where the county can no longer offer services to those holes because of the distance or whatever, or they're having difficulties because they're so far into the city. And you use the word connected and contiguous. And am I to assume, or we to assume, that when a city annexes, they have to be contiguous and have to be connected, but the county does not have to be left in a contiguous or connected, even though the county does technically go through there? But when you start looking at services, different things, and there are places that are isolated, that it's very difficult to offer the services that should be offered. What, I don't know if you see where I'm going with it, but that concerns me. It should
do.
be an area of concern.
And I think, and again, I think it's something we all do by accident, but we kind of talk about these like they're two different things. I mean, just because it's the city does not mean it's not the county. So there's never a break in our boundaries, because it's still the county. So it's not a donut hole for county. I think maybe Virginia is the only state that actually what's in the town is not actually considered the county. So I don't think there's an issue for the county. There could be some question, and again, I'm about as much the expert of what I read today. Okay, I'm not a lawyer, and I'm not going to wade too deep into the challenges piece on some of that. But as a rule, I think holes are certainly not the ideal way to leave a situation as the city expands. That leaving an actual hole in the middle is not ideal.
And I think, if I could, Representative, I think that also speaks to the challenge of service delivery. If you're a 911 operator and you're answering that phone, who are you supposed to send? Are they, is it the sheriff? Is it the city police? Who is supposed to patrol that? Which ambulance service is supposed to go out there? And while interlocal agreements are ideal for when we can all get along and no one party suffers more than another when that occurs, I think that does speak to the challenge that some of our counties certainly have when it comes to service delivery.
Just a comment, Mr. Chair.
You may.
And that, I think that's driving. I do understand that the county's still the county. Don't get me wrong. But I'm looking in a service aspect where, you've got a city policeman sitting 2 blocks away, and you got a county sheriff on the other side of the county that's, and how can you properly or adequately offer the services that individual, that property owner deserves, or whatever. And I understand there's been property owners that I don't want my land in the county or in the city, and they create the hole, and I just that just gives me some concerns, and just share that with you. Thank you, Mr. Chair.
Any other member have any questions? Okay. I do have one quick question on the 30,000 number. Can you give me your perspective from the counties? 40-year-old law, 30-year-old, whatever it is. Where do you see if that moved? And what would be the implications if that 30,000 moved? What does the county see that? So it was brought up in the presentation. So if it went to 25, went up. If it went up, it went down. Can you explain that a little bit from your perspective?
Sure. I mean, we don't suggest there be a threshold, and because I think it creates sometimes, again, and we struggle with this, and I've talked to some of you all about how difficult it is to understand local government. I didn't understand it much till I got in it either. I mean, the existence of the county and the basic services, and as Chairman Bridges talked about, the services that the county provides aren't necessarily the same. And so the existence of the county itself, the responsibilities, the constitutional duties of the county aren't not there on different size counties. The responsibility of the jails is one of our largest expenditures, obviously. That's unrelated to where your boundaries are. I mean, that's just a responsibility of the county. The elections, the list of things that the county clerk's office as the recorder of all the documents and deeds. I mean, it's irrelevant what size your county is for county government to exist. So I really don't know the rationale behind any population threshold by which someone would deem that the county no longer needed the revenue to exist. I mean, it would be a number that would have to be somewhat arbitrary. If you took 30,000 and you adjusted it, for inflation, and I don't know what that number would be today as far as a population number, but there would just be another point, another dot on the map or on the timeline that in some day would not make sense either as counties and communities continue to grow. So, I mean, we certainly have never advocated for any threshold. Our position would be that there should not be a threshold by which that changes for a county.
And I would just add to that, I've been doing this for 25 years, and this conversation has come up back and forth, obviously started before I even did. But, yes, you pay property taxes to a city. Yes, you pay property taxes to a county. And so the argument that, well, our citizens pay property taxes to the county as well, and that should do it. Well, I don't know of very many cities, much less counties, that survive strictly on property taxes. Quite frankly, nobody likes it. You all don't like it when your county property taxes go up. I don't either, but we're limited in the ways we raise revenue, and so we've got to have other ways to do that. But when you plan, when you're a county under 30,000 and you've put the money into the infrastructure, or you've made plans with incoming businesses, and annexation occurs and you pop over 30,000. That's a problem. Under 30,000 is the majority of the state, and so our members, and a lot of our members behind me are from counties that are under 30,000 that don't understand why these few counties that are over that 30,000 threshold have to live by that different set of rules.
Thank you. President Sivers.
Thank you. Mr. Chairman, I want to go back to Representative Pollock's question about the 30,000 and JD, wherever he may be back there. I actually turned around and saw the judge over here, and you all starting to look a lot alike these days.
I was going to say, JD's just shorter, Mr. President.
But
Poor JD.
correct me if I'm wrong. Any party on this, the smaller counties under 30,000. And I'll use my home, and I see my mayor and my judge from Whitley County back there, Corbin. For Clay County, who is at 20,300, they've instituted an occupational tax. They get to collect it. They're not over 30. If the city of Manchester institutes it, it's in addition to, it is stacked on all those individuals who live in the city of Manchester. Therefore, if it's a 1 and a 1, they are looking at a tax liability of 2% of their income, which in essence, occupational tax is an income tax. Is that correct? You go to Whitley County, population over 30,000, a larger county. Generally, our larger counties have a bigger tax base. That's why they're larger, and that all works. More jobs, things of that nature. Judge White institutes an occupational tax. He collects it till the city of Corbin institutes theirs. Then the people in the city of Corbin get a dollar for dollar offset. Therefore, they're only paying 1%. Correct? So the smaller counties are actually put at greater risk of tax liability than larger counties are. Generally have more jobs, more opportunity. That's why they're grown. That's why they are there. So smaller counties have a heavier potential tax burden, which if you want to look at the demographics and the socioeconomic status, generally the smaller counties are the poorest counties. Does anybody want to disagree with that assessment?
Representative Meredith?
Thank you, Mr. Chairman. I hate to come back around again, and I'm kind of going to pose this as a question because President Stivers and I were up here kind of kicking this around a minute ago, back and forth. As far as the members on this panel, he's the only person that's been here longer than I have at this point. And he wasn't here in 1986 even. I was a year old. But
Had to say it.
my question was going to be this, and I, honestly, as I look out amongst the group of people, because I know a whole lot of the city and county officials that I see out here today. I don't know all of them, but I know a lot of them. Is there anybody with us today that was in an elected position in a city or county in 1986 when this all became policy? Richard, maybe?
I was, yes.
So here's what my question is, and you may be able to answer this, you may not be able to answer this. Do you remember what the debate was at that time and why the 30,000 threshold was set at 30,000?
No, sir, I don't. I was in Christian County at the time, and
Hey, Richard, could you come to the mic? Yeah, if you don't mind.
Come on.
Yeah. Please introduce yourself and then continue.
Thank you. My name is Richard Tanner, and in 1986, I was a magistrate in Christian County, Kentucky. That was when the law was enacted, and Christian County and Hopkinsville did not have an occupational tax then, and they don't now. So it was not a big issue at that time, even though, they were much over 30,000 then. However, if you look at some of the annexation, they are I consider strip annex now down there, all the way down to Oak Grove, basically. Even though I live here now and I'm a magistrate here now, and that's the past. But the answer to the question was, yes, I was a magistrate in 1986. I'm old.
Like I said, and I guess what I'm trying to get at is here, sometimes we don't understand why something happened until we can figure out why it happened. And I wish we could find some way to figure out what the reasoning was behind that. And again, as President Stivers said, it may have been completely arbitrary at the time. It may have been that it only affected 2 or 3 counties in the state who were over 30,000. I don't know the answer to that, and I don't think clearly anybody in the room knows the answer to that. And so I wonder about that for one thing. And the second thing I wonder about, I see one of the judges back in the back that may have some insight into that. So Judge White, that's Judge White, I think, isn't it?
Yes.
My name's Pat White from Whitley County, and I did quite a bit of research on this several years back. And my understanding is that when the 30,000 was established, it was designed to be a benefit to the bigger counties so they could pass an occupational tax, because counties did not have the ability to pass an occupational tax. So the legislature granted a limited number of counties the ability to pass the occupational tax, though only the ones over 30,000. Well, then a few years later, and this would have been in the 60s and 70s, a few years later, the legislature came back and gave counties general taxing authority under a different statute, but didn't repeal all of the original statute. So what had been a benefit to those larger counties became a handicap.
And I think the population was 50,000 at one point, not 30,000.
And that would track, and again, all of us in city and county government who have talked about this for years, that 1901 provision in the Constitution that we continue to talk about related to sales tax and all those kinds of things, that was originally meant as an expansion of taxing authority, and today we now see it as something that hamstrings what we can do at the city and county level. And so it may very well be one of those same things where it was meant to be an expansion at the time, and it has become the opposite at this point in time. But the other question that I had too, and it goes into this a little bit more too, I know there's only 2 counties that were affected by this, but the referendum issue on Kenton and Campbell, I think it is, if I'm not mistaken, up there. do counties have the ability to have a referendum in those above 30,000, or was that something that was only granted at the time when those counties did it?
I don't know the answer to that question right off.
Find out.
Because I thought they were just grandfathered somehow or another. I didn't realize there was a ref.
I know there were other there have been types of taxes that have been referendum that later weren't. I know like our library taxing district, or excuse me, our ambulance taxing district was a referendum tax back in the early 80s, but you can do that by ordinance now. So I don't know offhand, but certainly can find out.
I guess what I was trying to get at there, and I'll finish with this, was, is there still something in the books that would allow for a county over 30,000 to have a referendum that would allow them to stack still active in the statute today? Or is that something that was only granted as a limited time when those were done? And I have no idea the answer to that. That's curiosity, pure curiosity.
I can tell you, we have looked extensively to try to find out the rationale behind it, something in writing, and haven't had much luck, but we'll be happy to try to look into that
All
too.
right, thanks.
Any other questions? All right. With that, I want to thank both of our presenters. Thank you very much, Keiko. Next task force meeting will be October 27th. We will be hearing from KLC. I appreciate everybody's attendance. We got to stand adjourned.
Thank you.